Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and my co-host today is Anora Wang. Hello, Anora.
Hi, Matthew.
Today's episode is What's Happening in Ukraine, a conversation with Timur Bondaryev. We'll be discussing recent developments in Ukrainian merger control and competition law enforcement, as well as potential changes to the foreign direct investment or FDI control regime. A lot has been happening even against the background of Russia's ongoing war against Ukraine. Timur is the founding and senior partner of law firm Arzinger, based in Kyiv, Ukraine. He's one of Ukraine's leading antitrust and competition lawyers and advises on M&A, cartels, and abuse of dominance cases. He acts before Ukraine's antitrust regulator, the Anti-Monopoly Committee of Ukraine, or AMCU, and in the Ukrainian courts. Hello, Timur, and welcome to the show.
Hey, Matt. Hey, Nora. Thank you very much. Thank you for having me.
Well, thank you very much for coming on. We appreciate it. First, I think it'd be interesting for our listeners to have an introduction to the Ukraine antitrust or competition law regime, and a bit of background and its history up to now. Please.
Yeah, so obviously this is a very important point to start with, to have a better understanding of why it is shaped in the way how it is shaped. So actually, after Ukraine regained the independence in 1992, the set of the laws of the new republic was introduced, and one of them in 1992 was the law on the prevention of monopolization. Being honest with you, on one hand, they were trying to, so to say, tap into the best global practices, but given that the country was very, very new, very fresh one, and we still had sort of a Soviet heritage, this law was very much, had a very, very Soviet flair. That means that the agency and the actual antitrust regime looked very much like, as they have introduced themselves, it was like economic state prosecution, right? It didn't have something to do with real antitrust, with real monopolies. It was more about, something like a new animal which we have to adopt, but we don't really know how to do it. Later on, the actually agency was established, and so it started to develop. But the main focus has always been actually mostly on mergers. And that was perhaps the reason why, at the very beginning, when the regime was established, 1 million euro, which was actually huge by that times, it was a bit lower in the beginning, then it evolved to 1 million euro. It was quite huge number for the fresh republic, for the new Ukraine, but it stayed in place for so many years that at some point it was already too low, and as you know, it actually caught each and every global deal, and yeah, so this is it. But the situation has started to change dramatically somewhere in 2016, after the first Orange Revolution, when the new management came into the office, which was much more advanced, which was much more, so to say, open-minded, which was really looking at the real best practices, and they wanted to, so to say, adjust the activities of the agency to the new requirements, to the new world. And this is where the new thresholds came and the new approaches came, etc. But this is just a little bit in a nutshell how it has been developing. And by the way, just a very interesting fact, a lot of people don't know it, that our antitrust legal framework back in 2000 when it was very much shaped by Dr. Deringer, Freshers Brookhouse Deringer. So he was visiting Ukraine quite often, and he was a member of this working group who was, so to say, helping Ukraine to shape the new antitrust legislation. And I was privileged to see, to say, on the same working group together with him.
Timur, thank you for that background. And just to be a little blunt, and you have already hinted at that, the AMCU, the agency, to some extent in the past, has suffered from a poor reputation, at least partly due to its merger control enforcement. What are your take on that? What your observations are, and what your comments would be?
Yeah, this is absolutely right, and I think that still we are very much suffering of this reputation, even though the agency has changed dramatically. So the roots of this problem are actually exactly where I have already started. Yes, so the agency has also been considered as the economic prosecution agency. I can still remember that one of the chairs of the agency, who was appointed by Yanukovych, our escaped president, he proudly named Anti-Monopoly Committee the fiscal agency, right? Which means that actually they didn't realize the actual purpose of the MCU, etc. But as I mentioned already, the new management and the younger generations of the management of the agency, they have totally changed this perception, and in the meanwhile, everything has changed dramatically. If we talk about the transparency starting from 2015, if I believe, yes, since 2015, all decisions of the agency are public, which was not the case before that. So, for instance, we didn't have access to the case law. Obviously, we've been doing a lot of antitrust work, but actually it was not publicly available. Or, as I mentioned already, the thresholds were like 1 million euro you're in assets or sales, etc. And actually with an access or no access at all. But even petrol sales, for instance, you had to notify the deal, which was a huge problem for everybody. And it's not a secret that, I mean, perhaps 70% of our clients, they have escaped, they avoided filings in Ukraine just because it was totally unpredictable. They could stop the clock if some papers were missing, etc. So very formalistic, very not really to the essence of the antitrust. But again, as I already mentioned, we've seen tremendous change. The thresholds were raised, as you know, the handling practices are much better, the transparency is there, and actually I think that they're how to say, client management and case management has dramatically improved. They've got much better people on board who understand very well the significance of this. And yeah, so it's been improving, I have to tell you. But the problem is still there, and I assume that we will talk about this a bit later. Given that Ukraine doesn't have FDI screening regime, the agency has always been vested with this unofficial power to politically screen the transactions. And this has always been not very comfortable position for the agency, because on one hand, they had to operate in antitrust terms, but sometimes they had to block the deals just because they were politically not really desired, and it had prepared a lot of problems for the agency and for the country, by the way, because one of the largest investment treaty disputes against Ukraine was actually triggered by the fact that the agency had to not really legally decline a major merger, which ended up in a $1 billion claim against Ukraine brought by a group of investors.
So, Timur, we'll get on to FDI and the current and recent changes.
It's great that we are we are having this conversation now, just because just beginning of October 2025, the draft law was revealed on introduction of the FDI screening, which is very much similar to the best international practices, something like it is in US, CFIUS, etc. Its consideration is still pending, but we believe that it's very important, especially now, in the situation where Ukraine is now given the Martel law and all the stuff. So this regime is very much needed. And my personal view is this regime is very much needed actually for the antitrust agency, just because again, unfortunately, they've been invested with these political powers to block unnecessary deals, undesired deals, and they were not able to properly focus on real antitrust. And if the regime is introduced, this will be very positive for the agency to get much better reputation in the global world, and just to allow them to focus on real competition issues, but not on political. However, I have to mention that given that, again, we didn't have this regime, the agency was vested with these quasi-FDI screening powers. Several years ago, they were allowed to block the deals if the parties to transaction on the sanction list, right? So this is like a legal reason for them to block the deal. And they've been using this power quite actively. But again, as we understand, we are antitrust practitioners. It has nothing to do with real antitrust, right? And they have to be allowed to focus on real competition issues.
So will the FDI regime be controlled by a separate body from the AMCU? It'll be a different entity dealing with it.
Yeah. It's again, as I'm telling you, it's more or less best practice. It will be like intergovernmental group, actually, various people from various ministries, from law enforcement agencies, etc., which will be evaluating the deal. And so I think that based on the draft law, there is also a representative of the agency, but they, as far as I remember, they were advised by the U.S. government how to structure this regime, and we expect that it will be more or less the same what we have in other mature jurisdictions.
Well, just really to address the elephant in the room, and then we've talked a lot about the situation that you are in, your country is in. But what has really happened? Is it a change, drastically different before February 2022? Or is it more of a situation that's changing, month by month, day by day, given that it's in a war zone and it's still full scale happening with Russia? So would you give us a little bit more on what the disruption that has caused by the war in terms of the enforcement of the agency?
Yeah, here is again something where I have to praise the agency, because obviously February 2022, Russians are literally around the corner from Kiev. Russian tanks are there, and everybody was leaving the country, right? And this was something what you were not able to control. Nobody was able to control. So that means that people were just jumping in their cars and leaving the country, leaving the Kiev. Despite that, so obviously first weeks following the invasion, there was a bit mess, but somewhere in March already the agency March or April was able to introduce a very special regime where they said, okay, guys, obviously we are now understaffed, there are issues, but you just, if you want to go ahead with the filing, please go ahead, please file for merger control, and we will just accept this. And then somewhere after the war is over, we will issue the formal clearance. But if you want to proceed with merger, please go ahead, proceed with merger against not significant fine. So that was actually excellent development. And I have to tell you that they were really very, very, very good on that. And already by the end of 2022, a lot of people were back in the office, even if technically they were outside of Ukraine working remotely, but they've been handling it very well. I have to admit, and our experience was very well. And even if you look at the statistics, so the statistics on the merger control filings has dropped a little bit, but it was still on annual basis starting from 2021, around 350, 400 something merger clearances per year. And so it didn't really drop dramatically in 2022. So they managed to handle the cases, even if they were working remotely, even if it was difficult. Well, you understand that the Russians are around the corner, etc. So huge kudos to the agency, and this is exactly the confirmation that they've done a great job in enhancement of their proceedings and alignment with the best practices.
And what about behavioral enforcement since February 2022, Timur? I think that's also been continuing, as I understand it.
Yeah, there were several cases, several investigations, several interesting cases pending. All usual suspects, more or less fuel retail markets, something on the life science, on retail, food retail, etc. But I have to admit that the main focus was on the enforcement against Russians. So the agency has been, so to say, focusing on all the assets which used to belong to Russians, and they did their best just to somehow block them or not to allow Russians to strip their assets, to get rid of them, because Ukraine has launched a massive nationalization campaign, and the idea was not to allow Russians to get rid of their assets, etc. First, second, the agency in Ukraine is very much involved into bid trading cases, as we understand, right? So public procurement, etc. So it's been extremely busy with public procurement cases. And by the way, while talking about the Ukrainian agency, we don't have to forget that in Ukraine they are vested with, as I say, not really natural powers which are normally with the agency. For instance, unfair competition is a huge area of enforcement of the MCU. I think that the number of cases which they've been handling like incredible. It's all about this usual stuff, misleading advertisement or something like that. And the penalties are quite high. So the penalty for unfair competition is in the same range as for gun jumping, up to 5% of the turnover. So which is quite significant. And they've been really doing a lot of cases, especially on those markets which have been very, very aggressive in terms of advertisement, OTC, pharmaceuticals, telecoms, financial services, etc.
So those are consumer protection type powers.
All right.
They have alongside antitrust.
All right. And it's a little bit double jeopardy because we actually have a very, very special authority which is in charge of the consumer protection. But the agency is also vested with the powers to take care of the unfair competition.
Okay. And on the antitrust side, are there any specific exemptions that have been put in place as a result of the invasion? I don't know, concerning, for example, cooperation on food exports or that kind of thing that's specific to the situation?
I don't not really in this particular area, but they've been very good on helping Ukraine to boost the defense manufacturing. So what they've done, they've voted the Parliament of Ukraine. They voted the law which allows to get a waiver for global deals related to defense, and to exempt them from the local merger control filing, provided that some special conditions are available. So they've been really good on that, and this is the reason why Ukrainian defense industry has been dramatically growing over the years, just because you don't have to notify them with the agency. But again, some of the deals, because we are now working on a number of JVs in this area which are subject to mandatory notification, but some foreign to foreign deals in defense sector, they can go without merger control filing.
Okay, that clearly makes a lot of sense. Timur, you've referred to this a bit a few minutes ago, but it'd be interesting to have a bit more detail on the current reforms that are going through. I think there's some further proposals to align even more with the general EU principles. So what can we expect to see, or what is happening in that area?
Yes, exactly. As I mentioned to you, so it looks like they are really very serious about antitrust. And I think that the president of Ukraine and a lot of members of parliament, they understand that the properly functioning agency, it's not only about antitrust enforcement, it's also about, being honest with you, about reputation of Ukraine, right? Because unfortunately, as you already mentioned in the very beginning, Ukraine and the Ukrainian agency had a very infamous reputation in this regard, and the politicians have realized that they have to do something with that. And this has ended up in a situation that over the last years, despite all these hurdles and hardships which you've been having and challenges, they've been systematically working on enhancement of legislation in this area. For instance, we finally have proper proper definition of full function, non-full function GD, what was not the case several years ago. It has always been, it has been implemented actually during the war, by the way. We have so-called the first antitrust package, which was enforced just 1st January of 2024, which has brought huge amount of very positive changes. One of them, for instance, that you don't have to calculate the seller's turnover, seller's assets while evaluating the merger, because it has always been a huge problem, because in Ukrainian deals that you have to also count the seller's financials, even if the seller doesn't really want to work in Ukraine anymore. Another very important topic has always been that they have thought of the actual enforcement of the judgment of the agency, because we had a number of cases against major oligarchs who got huge fines from the agency, and then they made their companies insolvent and it was impossible to collect the fines. So this package, which I mentioned already, provides for joint and several liability of the UBOs, etc. So in case if the company was fined and you want to make it insolvent, no worries, UBO will be also liable for this. So they have really done a lot of efforts in this area. Another very important point, starting from the 1st January of 2024, the actual control is considered in a way that you don't have to, it's actual control, real control. Previously it was, you have to file with 25%, which is nonsense as we understand, right? So now it's real control starting from 50%, and again, real control. So this is the so-called first package. The second package was expected to be adopted already with the beginning of 2025, but still there are some political considerations and there are huge developments also which are in the draft bill. For instance, international cooperation with the agencies, which is now not the case. So the agency cannot really cooperate, exchange information officially with their peers in other jurisdictions, or they seriously think of introduction of the notion of bargaining power. Another very important potential development would be that they want to finally allow to cover the auxiliary restraints by the actual merger control filing. Because if you know that now you have a deal, right, and you have usual merger, but there is a number of covenants like non-compete, etc., and you have to go ahead and file for merger control, and then you have to separately file for concerted actions just to get these auxiliary restraints approved. So this is all in the pipeline, and we hope that it will be very soon adopted.
Thank you, Timur. It's very helpful to know. One thing that we haven't talked about is private enforcement. What is the lay of land like in Ukraine? Like, are there business or individual consumers or consumers as a class bringing lawsuits under the competition laws or even consumer protection laws? We're not really talking about consumer protection, but what is the situation like? Do consumers and companies have a right to sue, and do they usually go after what they're seeing?
Yeah.
Are there private enforcement?
Yeah. So obviously the law provides for double damages. And actually, there were some cases, but somehow still the judicial practice is not really moving properly, and the standard of proof is still very bad. The actual practice is not really developed, and there are not so many real cartels. And what we also see that the agency in their actual judgment, they don't really focus on the actual economic effect of particular cartel, etc. This is why we have the legislation. We have already some cases. The largest one was in 2018, I believe. That was about $4 million, I believe. But the cases go very slowly. Just judges, they are not really ready yet to take, so to say, the responsibility. And it's interesting that the majority of cases were against the Ukrainian railways, right, which is a huge monopoly. But again, not so many cases, and it's still underdeveloped.
I think underdevelopment may be a situation that it just has to be addressed over a long time. But what has been the effect of the war, right? Like, I just want to separate that out. Are there effects on private enforcement because of what's going on with Russia, what's going on with the country right now overall?
We don't really see very active enforcement in this area. And being honest with you, the clients not really. I mean, antitrust is generally in Ukraine is very, 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 very young, as we understand, right? Even if our regime has been around for many years, but the businesses still don't really understand how to properly use it, because the perception on the market is generally that the agency is something what is like hostile. And we've been always trying to explain to our clients that, you know what, the agency can help you a lot just to enforce your rights. And it's still coming. But during the war, I don't really remember any particular issues, because any particular cases or efforts, even if we were trying to recommend our clients to bring some claims. And also, if you look at the real cartels, there were not so many real cases where you would be able to have some, tangible, some sizable claims and bring clients to the courts.
It's interesting to hear about that, Timur. So maybe something that could play out, but perhaps slowly over the next period. So that's a great discussion. We've really learned a lot about the past and current future situation in Ukrainian antitrust. We like to finish off our episodes, as you know, with a couple of personal questions. So we're going to ask you what we ask each of our guests, which is, could you please tell us something interesting or unusual about yourself that we would not know from just working with you professionally?
Yeah, apart from being a boring lawyer, I'm a passionate trail runner. I do a lot of trail runs. This is something what helps me to clean up my mind, to keep my mental health in a really good state, especially now during the war, right? I mean, to spend time outside in the woods, in the mountains, and just to run a lot, to spend time with running buddies. And this is something what really brings me a lot of joy and helps me to keep myself in a good shape, not only physically, but also mentally.
Can understand that. What's your normal kind of distance and elevation gain, Timur?
Oh, you know what? It depends actually, but yeah, I've done, for instance, several years ago, Transalpine running during the week from Germany to Italy. It was like about 250 kilometers. Overall gain about 15 or 16,000. Then yeah, so this is something what I mean. Several years ago, I did 100 kilometers trail, about 6 kilometer gain. So it's fun. It's fun.
All right, you're obviously a very serious runner.
Yeah, I'm getting older actually, but yeah, I do my best just to run at least one marathon per year, and just to keep myself in shape, and obviously to climb a lot of mountains.
Great. We like to finish off our episodes as well with our Curious Hat.
And now it's time for the Curious Hat.
So the point of this is basically to give us a second chance to ask you some silly personal questions, except that this question can be random, corresponding to a number that you get to pick from 1 to 21. Would you please give us a number?
Number two.
Number 2. When you were a young child, what did you want to be when you grow up?
This is something, you know what? Actually, there were several ideas. One of them was to be a captain of the U-boat, actually, just because an uncle of myself was the captain of a nuclear U-boat by some times, right? That was one idea. And the second idea was I wanted to be a diplomat, right? I wanted to work for the country. And the reason was very simple, because again, I was raised in the Soviet times, and I desperately wanted to travel the world. And in Soviet times, the only chance for you to travel would be to become a diplomat, right? So this is the reason why I actually ended up in the University of International Relationships in Kiev, but I made international law, and I realized that being an international lawyer perhaps in the modern Ukraine is much, much sexier than to be a diplomat, right? But, perhaps one day when I retire, I can be an ambassador or somebody of Ukraine in another country.
Yeah. Well, see, now you must have traveled many more places than you have imagined when you were a child now.
Absolutely right.
What is one or two of your favorite places that you have visited?
Oh, really? You know what? Yeah, I really traveled around the world, but there are still some countries which are on the top of my list. I think that Australia, Japan are really on the very, very top of my list.
Oh, that sounds great. We wish you would have your dream job one day and to travel even more places as an ambassador.
All right. Thank you very much. Thank you very much, Anora. Thank you very much, Matt.
And with that's the end of this episode of Our Curious Amalgam. Thank you all for watching, and thank you, Timur, for joining us, and thank you, Matthew, again for being a great host.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.